Good morning, everyone. We are here today to have this webinar, which is the second webinar for the first webinar that we did. This is a repeat of yesterday's webinar. We might be able to take more questions today after learning from yesterday's session. We might be able to take some questions on the go today instead of keeping them for the end. I will request our chairman, Mr. Anil Goel, to perhaps share a few words with the attendees who are already here. We already have about 200 people and we are waiting for more to join in. So maybe we can wait for them for 5 more minutes before starting up. We're also resolving a technical difficulty in having Mrs. Manju Agarwal joining us in the meantime.
Good morning, all the participants. It is a pleasure again this Sunday morning that all you connected with us. And it is as everyone knows, that it is a repeat session of the same as we did yesterday. Yesterday we touched our maximum limit, which is 1,000, and 1,000 people participated. 1,357 people could register for that chapter 1 of this subject. The subject, as you know, is the Insolvency and Bankruptcy vis-a-vis the SARFAESI Act. So what we thought yesterday was it is important that we should appraise about SARFAESI Act before. We should talk about SARFAESI Act before we start comparison between insolvency and bankruptcy and SARFAESI. So yesterday was a wonderful session and we received 100 questions online. Besides the questions that we received, besides the request for the sharing of the PPT and videos, as I would say that the video, of course, would be shared today. We would be sharing the video on our AAA Insolvency YouTube channel. I might even say that the video has actually come up very well. This would be circulated also to the link of the YouTube would be circulated also to all the participants. So the friends, we also requested Mrs. Manju Agarwal for becoming the moderator today. Somehow the technology problem that she is not able to connect so far. She is the Deputy Managing Director of State Bank of India, retired recently, and presently undergoing an assignment with State Bank of India only on contract basis. She is a friend to us. She's a family friend, and we requested her, and she consented. We are actually, I'm still trying to see whether she's connected or not. And I can still see that she has her mic and even the video is not yet connected. Great. Then as I said yesterday, the SARFAESI and insolvency, these would be the two options available for all the defaults. Insolvency and bankruptcy would be available for corporates, means the companies and LLPs or any other incorporated bodies. And also it would be available for the personal guarantor to any corporate loan. Whereas the borrowers are huge in our country and all other borrowers are covered under SARFAESI Act. SARFAESI Act is still applicable to a large transactions, large defaults, whereas the insolvency is only applicable to a few defaults. However, the insolvency actually got popularity only because of the rights of the creditors to pursue and to seek insolvency of a company in case the debt is not paid. Yes, we are able to hear you. I think Ankit, we are able to hear another voice now. We should tell Manjuji that yes, it is actually getting connected. We are able to hear, but it is
Hello?
Yes, we are able to hear you now. Agarwal Saab, we are able to hear you.
Oh, okay. But my video is not coming, no?
Video is not coming, but then we are able to hear you. And like even if I'm trying at my level also, there is no possibility that I can switch on the video. Only the
No, video is coming. I can see
moderator.
my video now. I hope it must be coming for you also. Share my
The
webcam.
video, yes, I think it should be coming. It is coming now. We are able to see
It's
now.
coming.
Now we are able to see you.
So if you permit me, Mr. Anil, I would want to speak a few
Yes,
words.
yes, absolutely, absolutely.
So,
See, Ankit, you can also keep your camera on. Ankit, can you also keep your camera on? Yes.
yeah.
So,
Very
like,
good morning to all.
we were waiting for, yeah, we were waiting for you, ma'am. Yes.
So, it's a pleasure to be a panelist on a session organized by AAA. AAA to me is not only a family firm. I believe they are doing pioneering work in the area of both SARFAESI and IBC. And if I'm permitted to make this statement, Mr. Anil Goel probably is the authority who has understood these two acts and codes by memory, and he can rattle out sections if you kind of pose questions to him. And the proof to it that wherever there is a seminar, a round table, a panel discussion, he is a permanent invitee, and despite his very busy schedule, he finds time to be a panelist. I keep asking, why do you kind of invest so much time into these sessions where you hardly get anything? He says, that's my way of learning. So I'm really enthused at his passion to learn and improve on his already very vast knowledge that he has about these two subjects. Yesterday we did the webinar for 2 hours, and I was thinking it is rather too long and probably people will get bored. But trust me, I am a career banker for 34 years. I found it as engrossing and as interesting as a 2-hour Bollywood filler. And at the end of the session, I kind of called him and asked him, why did you stop? You should have continued. And then he said, if he has a admirer in me, he said, okay, you participate in tomorrow's session, we'll make it more interactive. So I believe most of the bankers must have hooked on to this session. Ankit was giving the numbers. We are all aware banks are facing the huge problem of NPAs, and that probably is the one reason that though we are sitting on huge liquidity, we are still not willing to lend government, and RBI have been trying very, very hard that we get into the lending mode. Probably we are wary of lending for reasons best known to all of us. The GDP cannot grow unless the credit grows at a certain pace, and government has been trying its very best by putting legal framework to resolve NPAs. And Anil Goel has been a practitioner both under SARFAESI as also under IBC, and a practitioner who has resolved hundreds of cases. So probably we have no better speaker than him on this case. Me and Ankit Goel, who is the managing partner of AAA Valuation LLP and also AKG Chartered Accountants. He's also a partner with AAA Insolvency Professionals LLC, will be moderator. We'll keep receiving your questions and we'll pose to Mr. Anil Goel as and when we find it is important to respond to these queries. There are questions that we received yesterday. I have jotted down the important questions in the some time in between to give some respite to Mr. Goel. I can be responding to those questions, and if Ankit deems fit, he can also respond to those questions. Now over to you, Mr. Goel.
Thank you, Manjuji. Thanks a lot for all the words, good words. But then certainly I would say that there are too many good speakers in this country on this subject. It is only your affection to us, to our family, that you speak these words. I am only a humble learner, as I always say, and I will keep a humble learner. I always say whenever even I post something on LinkedIn that this is what I have done, but I have done only because this is my way of learning. And this is right that you said that, yes, I'm doing it for my own learning and I'm not doing any kind of charity. It is only my passion. It is only my learning. And rather you are supporting us in this path. That's wonderful. We thank you a lot. So, Ankit, with this, should we start the main session, which is SARFAESI, or even before that session, you would like to say the
I think
format of the day, that you should say something about the format, because you said that you would actually have something like after 30 minutes, we'll take 1 or 2 questions every after 30 minutes.
So, as you speak, I believe that the attendees can raise their hands. We can even ask the attendees to speak out their question. If that question is related to the slide that Mr. Goel is sharing, we can also look at the questions that are posted by the attendees, and we can ask those questions to you, so that you can concentrate on your deliberation, and the questions can be your attention can be invited on the questions by us.
So, Ankit, would you be able to give audio to the person who raises hand?
Yes, we should be able to do that. Yes.
And I actually received a couple of requests, like from Sanjay Gupta. I received a request that he would like to ask some questions in case the video and the audio can be given to him also.
We can try that. So I think let's start with the session, and in the meantime, I'm also resolving. So the panel, I'm trying to add the organizer panel on my system. So I think in the meantime, you can start, and I might be able to add everything and get everything started.
So okay, participants, like I know that most of the people who have registered, they have joined it today because this was a wonderful time, Sunday morning, like after everyone is free from the breakfast. I think this is the time for a good sharing of knowledge. I will just go to my slide as usually. This seminar is again, it is basically a webinar on insolvency and bankruptcy vis-a-vis SARFAESI Act. This is chapter 1, and the chapter 2 would be on Wednesday in the evening, same times like 4 p.m. and it will be for 2 hours. And that session would actually include the overview of insolvency and bankruptcy law and the experience of AAA organization while handling 27,000 SARFAESI cases and 153 cases of insolvency and bankruptcy. Based on the experience, the analysis that we have done, like what kind of cases are suitable for SARFAESI invocation and what kind of cases are actually suitable to invoke IBC for best value realization and for faster results. See, like while I would be continuing my discussions, all those people who have suffered some losses and they are presently worried about SARFAESI action against them, and maybe in chapter 2 in case they are worried against the insolvency actions. So they also would find various arguments that they would actually relate to their case and they can present to their lawyers. So this particular webinar is not only beneficial to banker, this is also beneficial to those people who have somehow incurred some losses in their businesses and they want to exit out, they want to get out of it, or they want some kind of salvage of their image or salvage of their regular livelihood. So going forward, I would say this SARFAESI law came in 2002. This is only the birth of this SARFAESI law came on in the year 2002. And the full name of SARFAESI law is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. It is with effect from 17th December 2002. Immediately, we also had the Security Interest Enforcement Rules 2002. Then the guidelines were also released by RBI for the registration and for the monitoring and for their internal control of asset reconstruction companies, and that was known as the Securitization Companies and Reconstruction Companies Reserve Bank Guidelines and Directions 2003. So all these three things, and then the law started as the insolvency and bankruptcy law started. Similarly, the SARFAESI law also started about 2002, long back. There was a very huge litigation that we have seen in 2003, and by the end of 2003, we saw a Supreme Court judgment, which is a very, very famous judgment in SARFAESI law, and that is Mardia Chemicals. In Mardia Chemicals, the Supreme Court, the constitutional validity of this act was upheld, and there were certain procedures in this insolvency, in this SARFAESI law, which was also upheld, like enforcement of security interest without any court or a tribunal. Second, like the sale of or taking possession of the properties under section 14 without any intervention of the court or without even having any appeal right. These were the issues which before the Supreme Court, but the Supreme Court finally upheld that. But Supreme Court also said that it all has to be implemented with a lot of caution. The secured creditors, means the banks and financial institutions, the ARCs, they were all were cautioned that this is not simply that you can use all your might. It has to be used very, very carefully. You actually have to treat the defaulter or any person who has suffered some losses humanly. And there were some do's, there were some don'ts, and that was given by Mardia Chemicals. And based on those do's and don'ts, and also kind of some modifications, then the central government came out with the securitization and reconstruction of financial assets and enforcement of security interest, removal of difficulties order. That was in 2004. So since then, the SARFAESI Act was continuing. The implementation was continuing because it never visualized, it never contemplated any additional infrastructure. It only used existing infrastructure, unlike IBC, because IBC is a complete different infrastructure, starting with the IBBI board and then coming down to IPAs and then the IPs, then IPEs. So, and then the IUs, everything is a different infrastructure. So IBC was a different infrastructure, whereas SARFAESI in fact used the existing infrastructure, which was the debt recovery tribunals and debt recovery appellate tribunals. There was no additional infrastructure created, but yes, the banks got a big power, and the borrowers started fearing the SARFAESI action. People were thinking of losing their residential houses, their flats, their properties, their factories, everything they started thinking of losing immediately, because this is the fastest possible action that we have seen. Like the biggest comparison between the IBC and the SARFAESI would be that the SARFAESI is much faster. So in 2011, the SARFAESI was also launched. It was started, which is a central registry, which is called SARFAESI. That was also started. However, like all this experience of 12 years, like since 2004 to 2016, it actually came as an amendment, which is called a very big amendment in 2016, which is called amendment to the, like that came through an amendment act, and that amendment in fact was applicable to different acts. So we are only presently attending here only to amendment to SARFAESI Act only. Then we also came down to the amendments in the rules, the Security Interest Enforcement Amendment Rules in 2018 with effect from 17th of October. So this this was the birth of SARFAESI law in the country. In case you see this entire act, it's not a very big act. Still, it has three major components and three different parts which are being used differently in different scenarios. So the first part is, of course, chapter 1 is only definitions. Chapter 2 is regarding the regarding the registration and monitoring of asset reconstruction companies by RBI, their rights, their obligations, their reporting requirements, and the transactions requirements. That is all monitored by RBI under SARFAESI Act Section 3 to Section 12. Second part, which is the important part, which we are taking up today and which we took up yesterday, and which is something that we can relate to IBC, that is chapter 3, which is called enforcement of security interest. And the AAA is presently only in the chapter 3. AAA is not an ARC. AAA is, of course, not involved in the central registry, but AAA is only under chapter 3, which is section 13 to Section 19 of SARFAESI Act, which talks about the enforcement of security interest. Security interest has been defined very clearly, because at the beginning, I would like to say that I would be using three terms again and again: security interest and the secured creditors and financial assistance. All these three things are very, very important, because I will come to the definitions. Because see, in the entire conversation that I would be doing with you, I would be using the word security interest, which you can relate to a combination of mortgages, hypothecation, pledge, and various kind of charge that normally a borrower creates while taking loans. So this is the enforcement part, and then the third part is the Section 20 to Section 26, which is a central registry. The government wanted to set up a central registry so that all the transactions of mortgage, pledge, hypothecation should be registered with central registry. The central registry, in short, which is called SARFAESI, and in full it is called Central Registry of Securitization Asset, Reconstruction and Security Interest of India, in short known as SARFAESI. It was founded on 11th March 2001. It is a complete organization. It is a digital organization which is set up for the registration of transactions, and all banks, ARCs, all are supposed to get the registration of the transactions. All the transaction has to be registered. So when I'm saying the transaction has to be registered, so it has now become mandatory with effect from 2020. So going forward, because today we will also be taking some questions, so I would actually be cutting some parts a little short. The amendment, as I said, the Amendment Act in 2016 that was implemented in phases. Some sections were implemented in 2016, and some sections, in fact, were implemented later. And the latest implementation of these sections is on 24th of January 2020, where three sections were notified: Section 17, 18, and 19, which finally corresponds to Section 23 of SARFAESI Act and the Chapter 4A of SARFAESI Act and Section 27 of SARFAESI Act, which was there in the SARFAESI Act long back, but it was not implemented. It was not notified. And these section belongs to the SARFAESI part primarily, and also a couple of other amendments. The SARFAESI part, as I said, that now from 24th of January 2020, it is mandatory for all the banks, financial institutions, ARC and NBFCs to register transactions before SARFAESI if they want to invoke SARFAESI and recover their money. So in case they want to invoke SARFAESI, the transaction must be registered with SARFAESI. SARFAESI is that kind of an organization now. Think of a situation that all mortgages, all pledges, all hypothecations are now registered with SARFAESI. So that SARFAESI also can be verified by, I think it is accessible to the public. Now SARFAESI has been opened for even private transactions. Any private transaction of mortgage, pledge, hypothecation, lien can be registered with SARFAESI by any person. So it is, earlier it was supposed to be for the banks. Now it is open to everyone. Everyone can register that transaction. So as I said, the constitutional validity of the SARFAESI was upheld by Mardia Chemical case, and also in Siddhi Vinayak Hotels Private Limited versus Union of India in 2006. So a couple of cases which actually continued in various courts, and later on, like the constitutional validity was, the courts stopped considering these kind of applications. One part which has been so far used by the borrower, that is the creating tenancy rights. That has been upheld by various courts, because if the bank actually cannot take possession from the tenant under the Rent Control Act, because the Rent Control Act is not supposed to be overriding SARFAESI Act. So if there is a Rent Control Act, if there is any valid lease, then bank or the authorized officer or even the Diem or CMM cannot order for the physical possession of that property, because the tenant's right is the first, and then is the rights under SARFAESI to DMM. So this was finalized in this Nippon Enterprises Madras High Court, and these were very, very famous judgments on the tenancy part of it. So at the start, I said that it is very, very important that we should understand the three important words of the SARFAESI Act. One is the secured creditor, and the other is the security interest, and the third is financial assistance. So the first is the secured creditors. So one, that the SARFAESI Act is not available as a tool for recovery to everyone. It is only and only available to a class of secured creditors. So first in that class of creditor is, as defined under Section 2 of SARFAESI, is the banks, financial institution, any consortium of banks and financial institutions, asset reconstruction companies, or any trust set up by asset reconstruction company. Asset reconstruction companies are normally taking assignment of debt from the banks and financial institutions. However, in case of debentures or in case of any other secured debt securities, the SARFAESI also would be available for invocation to debenture trustee appointed by any bank or financial institution, debenture trustee registered with SEBI and appointed by any company for secured debt securities, any other trustee holding securities on behalf of a bank or financial institution. And the last entry was made to the list of secured creditors was NBFC, non-banking financial companies. I will come how the financial companies, how NBFCs came and became part of the secured creditors, maybe in the next slide. Unsecured debentures would not be covered under this as a secured debt. As I said, the first time the central government thought about NBFCs was in 2016, and on 5th of August 2016, the government notified 196 NBFCs as financial institutions for the purpose of SARFAESI Act. And there was one thing common in all these 196 NBFCs, and that was the total assets of more than 500 crore. So when I say that the RBI thought that this benefit of SARFAESI should also reach to NBFCs because they were also not able to recover money. This was notified as a financial institution under Section 4 of the Companies Act. Then later on, the further eligibility was enhanced again through this notification on 24th of February 2020, very recent. And now the NBFCs, whosoever are having assets worth 100 crore plus, as per the last audited balance sheet, they would be entitled to invoke SARFAESI for any recovery or for any enforcement of security interest. But the normal limit for any bank or any financial institution or ARC to invoke SARFAESI action is at least 1 lakh of rupees of outstanding balance of loan, whereas for NBFCs this was kept at 1 crore in 2016. However, now in 2020 it has been reduced to 50 lakhs. Now, as of today, all those NBFCs having asset worth more than 100 crore, they can invoke SARFAESI action for any debt which is 50 lakhs or more. 50 lakhs is also like having couple of components. It can be a single loan of 50 lakhs with more security interest with more assets. It can be multiple loans aggregating 50 lakhs and the single asset, and it can be multiple loans with multiple assets. However, the cross charges are required. Next is the multiple loans aggregating to 50 lakhs and multiple assets having no cross charge, but owner is one. Then I said the three things are very, very important. One is the creditor, the secured creditor. Now is the security interest. Whenever we invoke SARFAESI, first of all, we have to see whether we are a secured creditor, like we are a bank or we are a financial institution or we are an NBFC. And second thing that we have to see that yes, we have a security interest or not, which is enforceable under SARFAESI Act. So what is security interest? Security interest in common, let me say, any right, title, or interest in any kind of properties for which has been given to secure a loan. In case we talk about tangible properties, the first
So
example
one of the relevant questions that has come in is perhaps from Mr. Tushar Chaudhary. He is asking us to go back to the SARFAESI for NBFC slide, and perhaps I will request Tusharji to raise his hand, and we can ask him to maybe ask his question. Mr. Tushar, can you please raise your hand so that I can give you access to the mic? Yes. Thank you. Mr. Tushar, you might have to unmute yourself. Mr. Tushar, you might have to unmute yourself by pressing the unmute button.
Hello.
In fact, I
Yes,
have
you're
unmuted.
audible.
we are able
Hi.
to hear you now.
Yeah.
Hi everyone. Hi, Mr. Goel.
Yes.
I just wanted to go back to the sheet wherein the applicability of SARFAESI was explained by you on NBFC. I'm part of an NBFC. This is an area where there has been a lot of confusion. We are an NBFC. We are also a PFI. We definitely have a asset worth of more than 500 CR, but there has been question mark in terms of as far as our project financing wing is concerned. Yes, there was no question about taking SARFAESI action, but sometime back there was a confusion that whether our equipment finance wing, which was not a PFI, whether it can invoke SARFAESI action. So while the definitions are now very clear,
very important, very important. The definition is clear. I could understand one, that it is an equipment. That means it is basically an equipment which is it cannot be a mortgage. It will be a hypothecation only, because
correct.
this is equipment is in the possession of the borrower.
Exactly.
Equipment is a movable item and it is in possession of the borrower. So you want an answer for the any movable item which is in possession of the borrower.
Absolutely.
Is that correct?
Absolutely.
Because see, I'm trying to understand it in a technical manner, because I will actually come to that slide, Tushar, and you will get this answer. Because your question is a movable item which is in the possession of the possession. I think certainly. So I'll come to the answer. I'll come to the answer, because I think this answer I will actually say on that sheet, maybe in one or two sheets from this. I'll come to that level, because that will be appropriate time to understand what I'm saying. What is the SARFAESI for movable? Like it is just like cars. So I'll come to that. So Ankit, I will take this question.
One related question to this. I'll just take a minute. So is there any ambiguity still that for an NBFC to be able to invoke a SARFAESI action, there has to be, different NBFCs with different kind of registration, or we will have different regulations under which they can invoke SARFAESI?
No, this is the same all the NBFCs, where the from 24th of February 2020 there was a notification number 856, and that particular notification, it was from the Ministry of Finance. The NBFCs having asset worth more than 100 crore, as per their last balance sheet, they would be entitled to invoke. The second condition is that it would be the total loan. The total loan should be more than 50 lakhs and not less. The loan should be more than 50 lakhs. So that is the present scenario. So there is no confusion. So Ankit, we can go ahead, and I'll return to this question. And is the so this is the, because when we were talking about the security interest, I think within this I will find the question answer for the Tushar also. So what is tangible properties, and then we'll come to intangible properties. The tangible properties includes movable and immovable also. See, when we talk about mortgage, there are like mortgages of like various kinds, like registered mortgage and the equitable mortgage. Charge this is a common word, charge. Hypothecation is used when the any property is in the possession of the borrower and is hypothecated to the lender. So this is called floating charge. Assignment of the debt is also a charge, and then this is all including Section 58 of the Transfer of Properties Act. So any assignment which is, or any transaction of creation of charge as per Section 58 of the Transfer of Properties Act, that would also be covered as security interest. Any right, title, or interest of any kind. Let me explain to you now the hypothecation. Some examples of hypothecation would be all charges except pledge. Hypothecation is called a floating charge. SARFAESI can be invoked for sale only after crystallization of the asset. That means after taking possession. I will give you an example of the hypothecation of stocks. The borrower may give us a statement of stock in the factory or even other locations, may be amounting to 100 crore. But then 100 crore inventory stock is not in my possession. It is not in the possession of lender. So the SARFAESI Act can only be invoked once the possession is taken by the lender. Then only the SARFAESI Act can be invoked. So the SARFAESI will actually help in taking possession. SARFAESI will also help in selling. However, the sale part would not come, and we are not able to actually issue a sales certificate. See, what I'm discussing is that there is a possibility that for properties which are identified properties, I can even sell the properties without taking even a possession. However, in the case of movable items, I would not be able to invoke SARFAESI, sell properties, issue sales certificate, go forward and getting it registered in the name of the buyer. That is not possible because I would not get that right till the time I take the possession of that movable property. However, in the case of immovable, that is not required. So I can even sell the property on a constructive possession, on a symbolic possession, which is not possible in the case of hypothecation. So the answer to Tushar's question is if it is an equipment. If it is an equipment, that's a movable item, and the equipment has to be first taken possession. Then only the SARFAESI action can be taken for the sale. For taking possession of the equipment, yes, we can even apply to Diem for taking possession of the equipment. So after taking possession, then we can sell it. So we are able to invoke SARFAESI, and possession is a must in such cases. Pledge is the transaction which are enforceable under the pledge transactions are not enforceable under SARFAESI Act. It is wrong written here. Because in these cases the possession is already with the secured creditor. The pledge assets are also not sold under SARFAESI Act. Pledge is governed by Section 172 of the Indian Contract Act. Some of the examples of pledge that we can give is the old system of godowns, and when there used to be a godown keeper, a representative of the lender bank, and that godown would be under the control, and the keys of the godown would be with the banks. In those cases, the SARFAESI is not applicable whenever the lender thinks that property can be sold, that asset can be sold. Now, recently, with the Amendment Act in 2016, even the lease transactions, even the hire purchase transactions are also covered under SARFAESI Act. On intangible properties, any right, title, or interest, assignment by way of security, not assignment by way of a transfer, license created on the property. So all the above must have been created in favor of a secured creditor to secure. So all this charge, hypothecation, pledge, whatever we have created, assignment, that has to be for the purpose of credit provided to enable the borrower to acquire the asset. If I'm buying an equipment, the lender has provided that equipment. Obligation to pay any unpaid portion of the purchase price. Yes, in case there is unpaid portion, obligation to pay, then we actually can create a charge. Any obligation incurred, tangible or intangible, and license of intangible asset, all this has to be, this is the kind of transaction that is covered under SARFAESI that we have to see. So these are some of the transactions, because I moved on to this slide little quickly because I wanted to explain lien and pledge, which actually is a part of my earlier slide, but it is specifically mentioned in section 31 of SARFAESI Act that these transactions are outside SARFAESI rights. So nobody can invoke SARFAESI Act for these transactions. One is the lien. Basically, lien is a right of retention, and then there is no power to sell. However, whenever any documents are created, for example, when bank give a loan for loan against fixed deposit, the loan is given by the bank and a lien on the fixed deposit is created. Now this is a lien, so it is not possible to invoke SARFAESI action for this. And the lien, the property can be sold with a letter, with the consent of the borrower. So most of the documents that you would see, the documents of bailment, margin money, earnest money deposit, fixed deposit, loan against shares, even factoring services, even the agent's lien on the principal property. In all these documents, there is one document which is called consent to sell or consent to liquidate the asset in case of default. So all these lenders, they take the consent letter before even the default, and that is the reason that they are able to break the FDRs. They are able to realize the asset. They are able to sell the shares only because that letter is already with them, and most of the time that you would see that letter is undated. So these are covered under section 170, 171, and 221 of the Indian Contract Act 1872. Then the second is the lien under the Sales of Goods Act. Lien under Sales of Goods Act is available to any unpaid seller. If I sell something to someone and I'm not being paid, and I have not even handed over the goods to them, it is still in transit, I have a lien on the goods till it is handed over, till the possession is taken by the buyer. So before the possession is taken by the buyer, if that particular period, it is the lien of the unpaid seller. So that is very, very important that we have lien, and that is enforceable under the Sales of Goods Act, but not under SARFAESI Act. There are other liens also possible in various other laws, and those are liens. So those are governed by that respective law, but the SARFAESI is not applicable on those laws. Coming down to pledge, again, like there are a lot of questions that I received on pledge. Whenever we have a pledge transaction, the power to sell on default is already there with the lenders, and this is covered under section 172 of the Indian Contract Act 1872. Some of the examples of pledge is pawning, pledge by mercantile agent, pledge of goods for loan, pledge of agricultural produce in silos, old godown system of funding working capital. So I think, see, Manjuji, like, can you just also elaborate what are the different kind of transactions that you might have seen in the bank for pledge or for hypothecation? Because your experience in the banking has been very huge. As I have explained, fixed deposit comes under lien. So what different transactions that you can just see which are covered?
All the margin monies that we keep for opening a bank guarantee comes under lien. When you give a loan against the security of a fixed deposit, that fixed deposit will come under a lien. Loan nowadays mostly against hypothecation of stocks and machinery. Very rarely do we go for pledge of stocks because the old system of keeping goods under lock and key is no longer found feasible. So most of the time we are giving loans against hypothecation of stocks and machinery, and wherever there is immovable securities available by creating equitable mortgage. Only in case of land properties where EM is not possible, we create a registered mortgage also. So pledge, I do not think is very popular these days, unless we decide to give shares loan against the security of shares. In such case, that those shares get pledged to the banks.
see, to the participants also, in case they can write on the chat box, like in case they have any kind of transaction which they want to understand, whether it is a lien, pledge, or hypothecation. So that would be actually very, very useful for all
One
the
of the
participants
questions,
to understand.
one of the questions that has come in is that participants might be you might deliberate on the concept of a cross charge and its implication in SARFAESI. So maybe you can take that up, and until that time, I can see other questions.
The cross charge is simply a kind of one loan, two loan, three loan, and having one common property, and everyone has all the loans have charge on that property. That is a cross charge. So the cross charge also can be seen like in case there are two entities in one group, or one entity is having loan, the other entity is also having loan from the bank, separate assessments, separate accounts. But both these entities belonging to the same group may even have cross charges on each other's assets. So that is the bank normally do only for having more protection and more security. So the cross charge as such is considered to be the same kind of if it is a hypothecation, it will be considered as a hypothecation only, but the only difference is that in case there are cross charges, then even if one loan is completely paid, the charge will remain for the other loan in case it is outstanding. Similarly, if it is a pledge and having cross charges on different loans and different properties, then all that loan has to be settled before the property gets free.
Another question that has come in is, can SARFAESI be invoked by a second charge holder?
What? Sorry, I couldn't understand. What is this?
Can SARFAESI be invoked by second charge holder?
Second charge holder would not be able to enforce SARFAESI because see, first of all, when we call about secured creditors, the secured creditors in total, in case there is a consortium, 66% of the total amount outstanding at the time of taking decision, they will have to give their consent for invoking SARFAESI action. Second charge is part of the consortium. First charge, second charge, any subservient charge is part of the consortium. And all those who have any charge on that property will become a joint decision maker. 66% of the total debt amount based on the total debt is required for any decision to invoke SARFAESI, for any decision to even sell the property.
And Anilji, does second
yes.
charge not mean it is subservient to the first charge? So unless the first charge is satisfied, the question of second charge will not arise.
So my understanding is of course the first, that is the distribution part of it. Whenever any asset is sold under SARFAESI, how it has to be distributed, there is a separate section for this in SARFAESI Act. It says that first of all, it would be all the cost incurred for preserving, protecting, and for all this sale process, or that has to go from the total sale proceeds of the asset. And then the second part is that the distribution of the asset, this distribution of the proceeds, and that distribution of the proceeds is based on the total amount outstanding, and that also including the priority of the charge. It will be distributed accordingly. So the only confusion that presently that we are dealing with is whether the second charge holder will also account for in 66% counting or not. That is the only confusion as of now. Whether the second charge holder would also be counted for 66%. No, to understanding SARFAESI to this level, I believe that only the first charge holder will take a decision and not the second charge holder. But while the distribution of the asset will come at that time, the first charge and the second charge or any subservient charge, they all will participate in sharing the proceeds of the asset.
There's one more question saying that in case of multiple banking, then can second charge holder invoke the security? I would say no, because it is
no. See, as I said, that the 66% of the total outstanding amount, whosoever is having the first charge on the property, Like in case, let us take an example. The first charge on the land and building is only with the term lender, and the term lender has now totally getting paid in the 10th or 15th year of the company. So there is only an outstanding of say 25% of the original amount. So they are still having the complete charge on the fixed assets of the company. And the working capital lenders now have grown to something like 1,000 crore. And the working capital lenders are having outstanding of 1,000, whereas the term lenders are only having outstanding of 100 crore. So the term lenders are having first charge, and the working capital lenders who are having second charge on the fixed assets of the property are having 1,000. So in these scenarios, I don't think the working capital lenders can take a decision for the SARFAESI action or for sale of the asset. It is only the first charge holder. They would be counted in 66%, not the second charge holder. However, the proceeds of the sale of the asset would be distributed in this manner based on the priority of each lender. So this would not be counted, and they know it will not be possible for the second charge holder to invoke SARFAESI action.
Yeah.
So Ankit, should we move on to a couple of slides and then again, because as we said that every 30 minutes we'll take some questions. Is it okay, or we should take some more questions now?
Sounds good.
So the section 31 further says that in the case of aircraft financing, the SARFAESI is not applicable because that is all monitored and governed by Aircraft Act 1934. In the case of vessel ship financing by any banks, the SARFAESI Act is not available. It is governed and monitored by Merchant Shipping Act 1934. The rights of unpaid seller, it is specifically mentioned under section 31 of the SARFAESI Act. The Sales of Goods Act as unpaid rights of unpaid seller is also not covered under SARFAESI. The property is not liable to be attached to executed decree. So this is one section 60 in the Civil Code of Civil Procedure 1908, which protects the personal assets of a human. And whenever there is a decree against any human, and whenever there is an enforcement on the assets of any decree, and these personal assets would be excluded from the enforcement. And these personal assets are, like whenever we say that all every asset of the person, that would actually exclude wearing apparel, tools, utensils, some kind of house, pension fund. So there's a complete list of assets under section 60 of Code of Civil Procedure 1908, and that section protects human from such kind of execution of decrees. SARFAESI is also not applicable in case the assistance, financial assistance is less than 1 lakh or the outstanding amount is 1 lakh rupees. Then very, very important, it is also not applicable to agricultural land. And the last is if the total amount outstanding is 20% of the principal and interest, it is not applicable. If the total loan is 1 crore and the present outstanding is say 18 lakhs, which is less than 20%, including interest, then the SARFAESI action cannot be invoked. So this is only to protect those people who are now at the fag end of the payment, and it is only 20% of the loan is outstanding. So the banks cannot go and take away the houses and properties.
We have a request from a banker to explain explain this with an example, because this 20% of the outstanding perhaps needs more discussion.
So I took an example, like suppose the total amount original term loan was 1 crore and the installments are being paid, and now the total outstanding is 18 lakhs because including interest, and the 82 lakhs have been paid by the borrower. So in this case, the SARFAESI action cannot be taken. However, in case the total outstanding is say plus to more than 20%, means more than 20 lakhs, including interest, then the SARFAESI action can be invoked. So this is only to protect all those borrowers who have paid 80% of the total interest and principal, so that the bank should take other remedies available. The bank should go to the Recovery of Debt and Bankruptcy Act 1993 rather than, or they can go to even civil court, but they should not go and take the asset of the borrower without involving any court, without the interference of any court. So this 20%, the remaining 20%, the lawmakers thought that this should actually be recovered through other sources, through other remedies available. And it should not be, because the SARFAESI is considered to be harsh action. SARFAESI is considered to be, because I know when our team go and take physical possession of some residential properties, how we feel how harsh it is. We feel that how, along with the police, our team just evict the people, evict the residential people who are residing there, and this is considered to be harsh. And most of them, probably in smaller towns, in real poor people, they would not have any other place to live. So they would actually go out of the home without much. So they would be just on road. People might have seen in movies that the lenders come and the person is out of the home, but we have seen even physically every day, because so far AAA has taken physical possession of more than 5,000 such assets. I would actually seek, in case Sanjay Gupta, who is the Executive Director of AAA Capital Services, in case he can come in and share some of the experiences and that the team faces when they go and take physical possession of the properties. This is one side. Then the flip side also that I would like to share, how the borrowers strip the property. I will come to that slide when I say that the borrowers strip the property to that extent, so that nothing is left for the lenders. So the hypothecation of motor vehicle is also another example, as Tushar wanted to ask a question, because see, this also, the security interest of the motor vehicle can be enforced under SARFAESI Act. First of all, the possession has to be taken. The Diem, when we apply some police help, when we apply to Diem for motor vehicle, the Diem does not entertain these kind of requests, because the Diem says that the identification of the property, location of the property has to be seen. Diem says that I would not be knowing whether where is the vehicle. The vehicle can keep moving across the country, where the Diem is having only a jurisdiction over the area where he is the Diem. So in case the vehicle is outside the jurisdiction of that Diem or CMM, then the powers of the Diem or CMM is not there to get you the physical possession of that motor vehicle. So therefore, regarding the physical possession of the motor vehicle, it is the other law. It is not the Diem or CMM order, but it is the Indian Contract Act and the police helps, and it is the Arbitration and Conciliation Act 1996, which is mostly used by the private banks and NBFCs. And the court orders are also taken, and the various court orders are taken for taking possession, and then the police also can come. So the first of all, the lender's own resources will identify a vehicle, and then immediately police help is taken, and with the help of police, the vehicle is taken in possession. In this scenario, there is a popular judgment of Supreme Court, which is in ICICI Bank versus Shanti Devi Sharma and others, and this is dated 2008, May 2008. In this, Supreme Court has held that, like, the facts of the case was one two-wheeler was picked up by some lender, and that person who was using that two-wheeler, in fact, committed a suicide, and finally he argued before the court that the suicide was only because of the humiliation that was caused by the recovery agents while they picked up the motorcycle, and it actually, because of the humiliation, he committed suicide. So the Supreme Court came out with the complete directions in this regard, that there has to be the kind of do's and don'ts for the taking physical possession of the assets, timings, the education of the person who actually is going, what kind of and what extent physical force can be used, and based on that, RBI guided and decided and came out with a notification that anyone who is involved into this recovery business or enforcement of asset, they would have to pass an examination. And now every recovery officer or every enforcement officer has passed that examination as provided by RBI, and then only he can be enrolled as enforcement agent or even recovery agent in the banks and financial institutions. In yesterday's webinar, I also received a question like, what are the options available for negative lien or mere restraint on property? I said earlier also that in the case of negative lien, the SARFAESI cannot be used, because this negative lien is not a hypothecation, it is not a mortgage, it is not a lien, it is only a negative lien. Negative lien is that that particular borrower would not be able to sell the property without taking consent of the lender, without taking consent of the bank. So this is not defined as a security interest under SARFAESI Act. So this is not possible that negative lien can be enforced under SARFAESI. So what are the remedies available with any lender who has negative lien on a property? The only remedy available is go to DRT, file a recovery case under this is the Recovery of Debt and Bankruptcy Act 1993, or even they can go to any local civil court depending upon the amount, because now you cannot file an application to DRT in case the total outstanding amount is less than 20 lakhs. Earlier it used to be 10 lakhs. However, because the DRT capacity and the infrastructure was a problem, so in 2018 central government decided to provide some kind of relief to DRTs. So the basic amount of 10 lakhs was increased to 20 lakhs of rupees, so that some expeditious disposal of cases would be possible, and some meaningful decisions will come, and not that the DRT, most of the benches would be overburdened. So now as far as this agricultural land is concerned, as specifically it is excluded from SARFAESI action, there has been a lot of litigation on this agricultural land. Why? There are various reasons. One reason, that in most of the old factories, the factories were set up after purchasing an agricultural land, and factories were simply set up on that land without even taking any CLU, conversion of land use, from the state government. Later on, even till today, there are various different areas in different states which are called decontrolled areas. These means that those areas are not controlled by the state government. So anyone is free to set up any factory on those areas who doesn't need any conversion of land use. So in all these cases, when I say that I have a registration with me, that means I have only purchased agricultural land from a farmer. I will actually get it in my name, mutated. I will get mutated in my name in the records of Patwari or Tehsildar. Then I'll set up a factory. So this is one example where the agricultural land is being used for the factories. And when I construct building, maybe building worth 100 crore, and the title deed for that land and building would only be the purchase document of the agricultural land, because I would not be having any other document for the ownership of this factory land and building. So whenever SARFAESI action is invoked against such factories, immediately the borrowers have been taking the plea that this is an agricultural land. This is what is already written in the purchase document. The borrower always say again that even the land revenue is also being paid for that agricultural land in the records of Patwari, and in some cases even the Patwaris also have not changed the use of that land in their records. It is still showing agriculturist. It is still showing the crop. So there are two records which is maintained by Patwari or Tehsildar, what is called Fard and Gardori. Gardori and Fard, basically it's a record of ownership of the land and the ownership of the crop. So these two records are still considered to be a title of the evidence of the title of the agricultural land. So the courts have held in various cases, that this is Supreme Court has held that the agricultural land is agricultural land only in case tilling or plowing of the land is taking place. So this is very, very important judgment of Supreme Court. Then there are judgments of High Court also, and that is merely payment of land revenue is not sufficient to establish agricultural land. The business of seafood is not an agriculture business, so that would not be considered as the SARFAESI Act would not be applicable. Cultivation of cardamom comes within the term agriculture, and the SARFAESI proceeding cannot be initiated. This is the Madras DRT judgment. Then we have the land planted with rubber be treated as agricultural land. That is also a good judgment. So agricultural land is settled. We have a couple of other Supreme Court judgments which actually comes at the end of my slides, because the time is only restricted. So I would just see, in case the time is available, I will use that. So the two things that we have seen, one thing that we have seen that this is a secured creditor, and the second thing that we have seen is the security interest, and the third thing that we actually have to see is very, very important. What kind of financial assistance was given? What kind of financial assistance was given to secure, to take this property, and for which financial assistance this property was given as a security? So the definition is given in section 2 of and this particular definition was also amended in 2016. First is very common: the loans and advances granted or acquired as financial asset. Because why acquired as a financial asset? Because it is also applicable to ARCs. Debentures or bonds subscribed or acquired later or purchased from the market is also covered under the financial assistance. Bank guarantees given, letter of credits issued, because we see whenever bank guarantee is issued or any LC is issued, on any invocation of bank guarantee or any devolvement of LC, the non-fund based facility gets converted into fund based facility. So it is a fund based facility, and this facility is secured with some collateral security, primary security. So all this is covered as a financial assistance for which this SARFAESI can be invoked. Funds provided for acquisition of tangible assets under the financial lease, hire purchase, and the conditional sale. This particular clause was added in 2016. Earlier it was not there. So presently it is applicable. The SARFAESI can be invoked for all the lease transactions or all the hire purchase transactions. Funds purchased for obtaining assignment or license of intangible assets, it's again like SARFAESI is applicable. Purchase of debt securities, SARFAESI is applicable. May it be secured debentures, may it be secured bonds, may it be deep discount bonds, and any kind of debt security is covered wherever there is a security. There is a security interest created in the name of the in the debenture holder's name, or in the name of the debenture trustee appointed collectively by all through any process of merchant banking or SEBI. The any other credit facility extended by the bank or financial institutions, this makes this the financial assistance definition as inclusive definition. So there are possibilities that we have some more transactions which are covered under the financial assistances. However, based on our experiences, that we see that the following types of the financial assistance transactions are not covered under the SARFAESI Act. For example, discounting of sale bills, discounting of purchase bills, bill of exchange, hundi, factoring services, transactions of pledge like pawning, pledge of goods. All these are not financial assistances which are covered under SARFAESI Act. So giving all these things, three things which are very, very important, which is basically the concept is very clear to all. I believe the security interest, secured creditor, and the financial assistance, all the three things when we see, then we actually have to see, like we are now invoking section the section 13 of SARFAESI Act. So let us see where we have to go. So although for invoking SARFAESI Act, it is not required that we should go. However, the adjudicating authority in the case of SARFAESI Act is the Debt Recovery Tribunal. We have 39 benches in the country at 22 locations. Recently, the eDRT has also been implemented. However, we hear and we also experience that there is a lot of vacancy in the DRTs, and the pendency of pendency and is very high. So a lot of applications are pending for decisions. The central government, as I said, increased the limit from 10 lakhs to 20 lakhs on 6th of September 2018, and that is of course to give some kind of effectiveness and to facilitate faster disposal. The central government is also trying to improve the infrastructure of DRT, DRATs, as they have announced a unified cadre for the staff of all the DRTs across the country, and that notification came on June 2018. Adjudicating authority, the appellate authority in this case is Debt Recovery Appellate Tribunals. There are 5 appellate tribunals in India: Delhi, Mumbai, Kolkata, Chennai, Hyderabad, and they all are having 3 jurisdictions now. I have written 2 in this slide. I will add 1 more in my conversation with you. One is, of course, the Recovery of Debt Due to Banks and Financial Institution Act. Now this act has also got a new name, and that is with effect from 1st December 2019. So this particular decision was taken by the central government, by the lawmakers in 2016 when they drafted Insolvency and Bankruptcy Act. In that Insolvency and Bankruptcy Act, they decided when they will actually decide when they will invoke the jurisdiction of DRTs under the Bankruptcy Act, under the Insolvency Act, then they will change the name. So when the personal guarantors were notified, the insolvency of personal guarantors were notified on 1st December 2019. Simultaneously, this was also notified that this act, the Recovery of Debt Due to Banks and Financial Institutions Act 1993, would be known as the Recovery of Debt and Bankruptcy Act 1993 now. So now this act is called, in short, RDB Act. So the second jurisdiction is for SARFAESI Act. Any application which is to be filed has to be filed under the SARFAESI Act to DRT. And the third, of course, as I said, from 1st December 2019, the personal guarantors who have given guarantee to any corporate loan for their insolvency and bankruptcy would go to DRT in case that company is not under IBC. So I will give you some examples. Basically, those companies where there is a guarantor and the company is defaulted. Now the banks are trying to recover money from the guarantor, and the company is not gone into IBC. Maybe the company has gone into winding up, or maybe the company has not gone into IBC because the company doesn't have assets. So the loan was given primarily on the net worth of the individual. So in all those cases, or maybe the bank has not gone into IBC, so it is only gone into recovery through SARFAESI. So in all those cases, the guarantor's case of bankruptcy would go to DRT. So before we start the SARFAESI action, we actually have to see the following things, which is now simple, because since we've understood security interest, secured creditor, financial assistance, we actually have to see that yes, there should be a default in repayment of secured debts or any installment. Also, the bank must have been classified that account as NPA, and then the NPA record is based on the Bankers Book Evidence Act 1891. And in case this is the loan which is, or the debt is like debt securities, secured debt securities like debenture, deep discount bond or bond, then NPA status is not required. Then single default or period default will be eligible for SARFAESI action. This secured creditor can enforce security interest without the intervention of the court or tribunal, notwithstanding anything contained in Section 69 or Section 69A of the Transfer of Properties Act 1882. So this is a very, very basic logic of SARFAESI Act to expedite the recovery, to expedite enforcement of security interest. The SARFAESI was brought to light, and the only objective of this SARFAESI is considered to be this: enforcing security interest without the intervention of court or tribunal, as far as this enforcement of security interest part is concerned. Whereas the different objectives were there for Asset Reconstruction Company and for CERSEI, for Central Registry. But for this central part of it, for this enforcement of security part of it, it was only logic that the enforcement of security interest is possible without intervention of the court. Then we already discussed security interest that should be as per the eligibility norms, as per the definition. Secured creditor should be as per the definition. Financial assistance should be as per the definition. The section 35 of the, it is just for the information, not a part of this slide, but it just is a part of information that this, like IBC, like insolvency, we have section 238, which is a non-obstante clause or an overriding clause. Similarly, section 35 is also there in SARFAESI, which is an overriding clause, and that's called a non-obstante clause. SARFAESI action can also be initiated concurrently with the DRT application, or or any action to take a decree from any civil court. Now we are going to start SARFAESI action. So from now, it actually will become procedural. And till now, conceptually, is there any question, Ankit?
Yeah, there are two questions relating to SARFAESI and IBC. One is, in view of suspension of IBC, do you think banks will now take recourse to SARFAESI action for realization of their dues? And the second question is from Mr. Ashwani Mehra. It is SARFAESI is always considered a value destroyer and IBC a value creator. But do you think it is a myth? Because 3 years of IBC being in vogue, there has been very little resolution. So these two are the questions.
So very good. I think the Mr. Mehra's question I will take first, and it actually has got more meaning of our topic, basically insolvency and bankruptcy versus SARFAESI. And the second question also I will take, because whether this suspension will come or not, that has to be seen. But Mr. Mehra, it is very, very important that we say, my answer is first to say yes and no. Yes in some cases, no in some cases. Whenever there is a company which is in operation, whenever there is a company where workers are working, whenever there is a company where a lot of assets are attached by various agencies, it is only the insolvency law which actually can bring value for the stakeholders. However, where the since this for the last 18 years now, the SARFAESI Act has been settled. SARFAESI Act is going to stay. SARFAESI actions are now actually becoming effective because of this amendment in 2016 for Diem orders, for CMM orders. The only difficulty that the country is presently facing is with the valuation. The valuations which are expected by the banks are not coming forth. So the banks are taking time in taking a decision. We have been able to create customers for each and every transaction, but the bankers, they don't accept the valuation as they are offering. So that is one scenario. The SARFAESI has become, of late, SARFAESI has become much faster. SARFAESI has become much faster because of various amendments. One, that the High Court and the Supreme Courts has actually stopped giving stays because of various Supreme Court judgments and various Supreme Court strictures. The DM and the CMM actually have not been sitting on various such orders for assistance to be extended to the authorized officer for taking possession. And third is that in case everything goes well, 60 days notice, DM order, and then the sale notice. So everything goes well, and the SARFAESI action can be completed within 6 months, including some time required for marketing of the property. Whereas insolvency, we have seen, one, that it is little expensive, two, that it is the time taken in insolvency is larger. So in case we are only thinking of liquidation of cases, wherever the borrower thinks that the liquidation is the only alternative, and the company as a going concern would not be taken over by anyone at a value which is acceptable to them, then in those cases, for smaller cases, it is the SARFAESI which actually adds better. However, SARFAESI is only giving value from the assets, whereas in the insolvency we are getting value from the other assets of the company. And also insolvency is a way of business in India, whereas SARFAESI is only a recovery process or enforcement of security only. The creation of value and the destroying the value. As I said, wherever the company is operational, SARFAESI action should not be taken. Wherever the company is having any business model, SARFAESI action should not be taken. SARFAESI action should only be taken when it is only about realization of a security. Whereas insolvency is still, we consider insolvency as protection for the business model. It is also like maximizing the value over and above the value of the securities underlying. That is not possible under SARFAESI action. I will also come to another slide, which actually will give you some perspective how value is destroyed by some of the defaulters. The other question that I have is very, very important. In case we get suspension on insolvency and bankruptcy code, which is there in the newspaper, although I believe I still read the statement given by the finance minister carefully, because I still think that the statement was that they would not push those companies to insolvency who actually have defaulted because of the impact of lockdown or COVID-19. Any NPA, which was an NPA even before the lockdown started, I don't think that would be covered under this whatever ordinance is coming, which the cabinet approval has been given. There's some, I think, section being introduced. Nobody has read that text so far, but I believe that it cannot be suspended for everyone. It would be suspended only and only for those people, those entities, those companies which are impacted only because of the COVID-19. So is that right, Manjuji?
I would also like to add here that perhaps as a community, as professionals, we need to spread the word that IBC as a process is not always against the debtor. In case there is a genuine reason for the default, perhaps there will be a consideration from the COC, and they will try and help the company revive with the existing promoters. Maybe you can add some more, something else to that. Also, there are a lot of questions that are coming in where because of individual, because of the defaulting, wherever there are defaults, what are the possibilities in SARFAESI or other laws against personal guarantors?
No, the personal guarantors are actually SARFAESI cannot be invoked against personal guarantors unless the personal guarantor has also given their property. SARFAESI is only an act to enforce a security interest. If there is a personal guarantor and the personal guarantor has not given any of his property to secure that financial assistance, to secure that credit facility, then SARFAESI cannot be started against that personal guarantor. Then it will be the RDB Act that would be started, because that would be a recovery. That would be a recovery suit under that RDB Act, and that recovery suit would be filed before DRT, and a recovery certificate would be obtained from the DRT. Based on that recovery certificate, then the individual assets of that guarantor would be found, and then there will be a separate process for the enforcement of decree, implementation of the decree. So for the purpose of implementation of the decree, one has to have assets. Otherwise, decree would be obtained by the beneficiary against the personal guarantors from DRT under RDB Act and not under SARFAESI Act. So now I think we should start this, how the SARFAESI actions are taken, because we actually have to, because already we have 52 minutes are spent. So the first thing that we actually have to think when the SARFAESI action has to be started is notice under section 13(2). Very popular. Anyone who is working under SARFAESI infrastructure ecosystem would actually know notice under section 32, which is to be given to the secured creditor has to give notice to borrower, and this notice is only to say that now you supposed to give the complete outstanding in full and final within 60 days from the date of this notice. This notice only says that, and this notice only indicates that we have now invoked SARFAESI and you have to pay within 60 days. So in case not paid, the secured creditor shall be entitled to exercise all or any rights under section 13(4). So this is the only notice, and in every notice now since the rules are amended in 2016, again in 2018, in fact the SARFAESI law has seen a lot of litigation because of the Mardia chemical case. The Mardia chemical, as the Supreme Court said, that all the procedures as mentioned in the rule or in the act has to be followed very, very carefully, because it is that you are taking over somebody's property and you actually have to give complete chance to them to represent and to submit their objections. You simply can't go and evict a person from his home or from factory or from office or from shop unless all these complete formalities are done. So a lot of litigation has actually been seen in SARFAESI law only because of some kind of errors which was done by some of the officers of the bank. So the promoters or the defaulters have been taking advantages of those errors, and then the litigation in fact was huge. I am also thinking of consolidating my experience of the last 17 years to work under SARFAESI, and I will list out one of various those common mistakes, whether by the bankers or whether any other person has been done, which has been consuming a lot of time under SARFAESI, and how now all those things have been mitigated by amendments in the law, by Supreme Court orders, or by way of even better understanding of the stakeholders in the law. I would actually prepare that scenario that would be focused only for the bankers, and then I would actually consider this as a complete consolidation of my experience of handling 27,000 plus cases under SARFAESI Act. The contents of notice are also prescribed in this case, the complete details of the borrower, the money payable, the particulars of the asset, and the notice should be issued by this authorized officer, whether the person is authorized or not. A lot of litigation actually have been seen in this part. The authorized officer under Rule 2A is a person of the rank of chief manager in a public sector bank or equivalent, and that there has to be a board of directors resolution also, so that the chief manager or collectively are authorized for SARFAESI action. Any other person or authority exercising powers of superintendence, direction, and control of business or affairs of the secured creditor. Why this is so? Because everyone is not a chief manager, because there are NBFCs, there are ARCs, there are private banks, so they would have different kind of posts, different scales, different ranks. So they would have they would authorize a person who actually is exercising the powers of superintendence, direction, and control of business of affair or affair. So this is what the NBFCs can think about. So the notice, like out of the various litigations in the notice part, we have now collated these things, that the notice should be complete in all respects, and it should be a complete transparent notice. There should not be any attempt of hiding any fact while the notice is being given. Principle of natural justice is applicable to service of notice, as we have seen in insolvency also. Whatever is mentioned in the IBC code, IB code, it is not being implemented only because of the principles of natural justice. Whenever we are actually starting CIRP for any company, that means it's a very big decision, and it actually can damage the financial, social, and various other aspects of a person's life. So it has to be invoked very, very carefully. So the principle of natural justice is always invoked. If the notice is not serviced, not received, I don't think there is any action under SARFAESI which would be valid. Notice is only a demand notice. It does not add any right to secured creditor. The creditor cannot say that I have invoked SARFAESI law, so this property is not owned by me. That's not something which is there. As I said, the effect of notice is also mentioned in section 1313. See, once this notice is given, then the effect of the notice is that the borrower shall not transfer by way of sale, lease, or otherwise any of the secured assets referred to in notice without prior written consent of the secured creditor. That's the impact of the notice. Even otherwise, the hypothecated asset or even pledged assets cannot be sold. However, this section 1313 specifically says that proceedings against guarantor pledged assets, that also is possible, but as I said, the bank can decide to go against a guarantor, and bank can even leave the the principal borrower. That's the prerogative of the banks or financial institutions to decide. However, as I said, the SARFAESI action can only be taken in case the property of the guarantor is mortgaged, and that is also secured to the extent of the property. In case the personal guarantee is given, that actually would be a separate case, which will go to RDB Act 1993, and that will be a suit for decree. Now, the first step is given, and the second step is also very, very important. So this particular step has also seen a lot of litigation. A lot of people have taken stay because of this section, which is 1333A. After the notice is received, the borrower will represent before the bank or raise some of the objections. Those objections or representation has to be considered by the bank. So that has to be considered within 15 days now. Earlier it was 7 days. And most of the delay in SARFAESI action has taken place only because these banks were not able to provide a representation answer or objections answer within 7 days. Now, like it has been made 15 days now since 2013. Earlier it was 1 week. So the banks have to say, in case the representations or the objections are not acceptable to them, they have to pass a spoken order, they have to give reasons, and finally they have to convey their decision. No, that we finally feel that the amount has to be recovered from you, so it should be recovered. So we are there. In case the banks feel that there is some reasonableness in the objections or in the representations made by the borrower, then the banks can even say that yes, we are ready to modify the notice, we are ready to even withdraw the notice. So all this is so whenever there is a withdrawal or modification required, then the 60 days will start again. So this part of the procedure is very, very important. However, it has been held by even in 17A also in courts that no cause of action can be considered for filing an application to DRT or for filing any application to any other court like High Court or any other court. So this is not a cause of action just by giving a notice under section 13(2), or only this is why the objections is not a cause of action. So some cases that I have listed here is Syndicate Bank, like Bala. So these are the cases that I shouldn't read the names, but these are the cases which are on this subject that I could come across in my practice. Now, this is the practical experience that we have gathered. What kind of objections are raised by the borrowers? What kind of representations are made by the borrowers? And which are supposed to be answered carefully by the banks, financial institutions, and these are supposed to be answered very, very detailed manner, why they are not accepting this plea of the borrower. The condition there, the objections or the representations are that the limitation law is applicable. Somebody can say that the debt is time barred. Second, the notice is not properly served. The notice has not been received by me. The notice has not been served by this mode as provided in rule. The notice has not been pasted. It has not been published. So there are various conditions on service of notice, and somebody can easily say that the notice is not properly served. Bank has not appraised any appraised and processed an application for enhancement of credit facilities, which was submitted by the borrower, and it has not been rejected so far by the bank. When the bank has taken an application for enhancement and that decision is pending, how bank can invoke SARFAESI and issue notice under section 13(2)? The borrower's request for trust and retention account is pending with the bank, because these are situations where the bank invokes the SARFAESI action, or even a bank stop the operations in the bank account. The borrowers normally give a request that I should be allowed to operate the account, and I should be allowed to open a trust and retention account or TRA account, or even it can be considered as an escrow account, with some tagging in my income or revenue that would be considered as recovery by the bank. For example, somebody may have a steel unit and somebody can say that yes, out of 2% of my turnover can be kept by the bank for my past outstanding. And somebody can say out of the rental income, maybe 30% can be retained by the bank. So this is called tagging or an escrow arrangement. Some examples that I have seen, like people are saying that the statement of account is not provided by the bank despite various requests. Some may say that I already have submitted a one-time settlement proposal and we have not received any response from the bank. They have submitted a restructuring proposal, rehabilitation proposal, nursing proposal to the bank, which the bank is sitting and not responding. The property is not in the possession of the borrower. The notice, the particulars of the property which is written in the notice is not in the possession of the borrower. It is in the possession of third party, maybe on account of the tenancy, or maybe on account of some business management arrangement. Property has been given on rent against a valid rent agreement, and even somebody say that like the stock details that you have mentioned in the notice is not in our possession. It has gone to the job workers, and since the operations are closed, now we actually have to take that stock from the job workers. So this is the part second part was the response by the bank. And now the third part is the what, like, so the notice has been given, the objections have been attended. Now this is the time that we actually can say that yes, we have to take the possession of the property. We have to take the possession of the asset, and then only we will have the right to sell, including the right to transfer and the various lease, assignment, or sale. The second option, which is available under SARFAESI Act, which was available in 2002 also, but it is not presently being used by most bankers because of the practical difficulties. This is the similar powers as in Insolvency and Bankruptcy Code. The banks can also take over the management of business of the borrower, including the right to transfer by way of lease, assignment, or sale of for realizing the secured asset, only if substantial part of the business is held as a security interest. So in case I have a business, like I'm running a kind of hotel, and everything of the hotel, like the equipment, land, building, and even the working capital is mortgaged to the bank, then the bank can even decide about taking over the management of the business, and that's provided under the SARFAESI Act. Bank can also appoint any person as manager to manage the secured asset, the possession of which has been taken over by the secured creditor. So the bank can definitely say that yes, we are taking over the possession of the hotel and we will run it, and the bank can appoint a manager. So these are the options available with the banks: A, B, C, D. The D is required at any time by notice, because D is regarding the recoveries. So the first part is the selling the assets. Second part is the taking over the assets. Third part is like, even if the assets are not taken over, the bank can appoint a manager who would work and who would have a control on the business of the company. Fourth is the bank will like to recover money from all those receivables, current assets, advances, refunds, claims. So that also the banks can recover under SARFAESI Act. So bank can write to all those sundry debtors that the amount payable by you to the company should be paid to the bank directly, and the bank can even issue the receipts, valid receipts, which will be valid for the debtor for making the payment. So we have seen the step third, and let's go to the step 4. And in the step 4, like once we have decided, like maybe like the most common part is, I will say, the A we are discussing first, and then we will discuss the B, and then we will discuss the C and D. Also, like B, C, and D is collectively we will discuss. And the first part, this step 4 that we are talking about, is only about this subclause A, which is taking possession of the secured asset. So fourth step that we are talking about is only for taking the first step, is under section 14(1)(a) for 13(4)(a), which is for the physical possession. For the purpose of physical possession, the SARFAESI has section 4, which says that the CMM, the Chief Metropolitan Magistrate, or CM or district magistrate, will assist the authorized officer in taking the physical possession of the secured asset. So this is the the power that we are saying that the CMM or district magistrate has. Even the application has to be filed by the authorized officer for taking possession of the asset and the documents relating thereto. The bank's application to Diem is that you take the possession for us, and also the documents along with it, and also forward such assets and documents to the secured creditor. That's what is the application. Affidavit has to be given by the bank because this a lot of litigation took place in the process of Diem or CMM orders. In the process of litigation, High Court came out with some kind of guidelines that these are the do's and don'ts by CMM or by Diem, and all these are very, very important. So finally, the central government made that part of an affidavit which is supposed to be given by authorized officer while the application is being made to CMMDM. Now this authorized officer gives an affidavit, and in that affidavit he says that each and everything, whatever is written in that affidavit, that I have already done. And for example, notice has been given, the amount has been verified, the total amount, asset detail, identification of the properties. So all kinds of objections that the DM used to give while not giving the order has been covered under that affidavit. So the response has been shifted to authorized officer and not to the CMM or DM. Now the CMM or DM they are supposed to give, because from 1st of September 2016, the CMM and DM, they has to give this order within 30 days of the application. So in case they have to delay it, they can only get it extended to 60 days, and that also by recording reasons that it was beyond his control. It is also mentioned that the CMM DM can also delegate their powers to other subordinates. So normally we have seen that when they try to get the possession for us, they also appointed Naib Tahsildar or any other SDM in some cases. So the DM now is completely a settled issue. Still, when we say settled issue, I would say we have a lot of experience in this case. I will come to that, because I think in this slide, I will say that what is the practical difficulty that we are facing. Here we are only saying the powers of the CMM DM. The DM may take all steps or may use force as may be required, and the DMs are normally using force. It is the police has to be taking the possession. The DM order cannot be questioned. It is specific section 14(3). Lenders can take possession without DM orders, and the possession and the sale would be valid. So this is also very, very important. In case we have to take possession, so it is not always important that we take the permission, or we take the order, or we take the assistance of DM. Assistance is not required. So not required if if it is a simple plot of land, and the bank can just go and take physical possession, put a like board there that this property is in physical possession of so and so bank, and anyone trespassing that would be questioned to that board, and then the pictures and then the videos can be recorded, and that's it. Then why to go for taking the DM permission or DM assistance? Not required. So even after that, the banks can sell it, and it will be a valid transaction. Whatever DM is giving the orders are being passed by DM, whatever actions are taken by the banks or the authorized officers in good faith, all that is protected, and no proceedings can be taken against them. This is specifically provided under section 32. The powers and functions of the CMM is also now being compared with the CJM, that means the Chief Judicial Magistrate. So what is now some banks are doing, that in case the DM is not giving orders, then somebody is trying to get these kind of orders from Chief Judicial Magistrates. So when we are in a metropolitan city, then these powers are given to CMM, and when we are in non-metropolitan cities, then the powers are given to DM. And the DM power is also something which is coexisting with the powers of CJM, Chief Judicial Magistrate, and in many cases now the CJM is started giving the orders. There is no such situation. The Act does not exclude CJM. So these are the various difficulties that we face while taking the DM orders, CMM orders. One, that there was no standard documentation or process in the offices of DMs across the country. Every state, every district, they had their own processes or documents requirement. Different time is taken by DMs in giving the order because of the local issues, over occupation of the magistrate. However, the amendment on 1st of September 2016, it reduced the timeline of taking DM orders substantially. We have a complete data now, and present scenario, wherever we have seen this, we are getting the order in 1 month, like in Delhi, Ghaziabad, entire Haryana, Chandigarh, Punjab, Meerut, Saharanpur, Himachal Pradesh. So these are some districts where we actually get the order within 1 month of the application. Even at most of the other places, we are getting the orders from Diem between 3 to 6 months. But I would say that still there are 40% districts in India where it is taking more than 6 to 9 months. The reason can be some of the local borrowers, they can influence the office of Diem. Then the Diem also can think in some cases that it is the kind of action that I'm going to do, the SARFAESI action, would be prone to law and order unrest. So he would not like to create any law and order unrest in case the asset is larger or involves or includes a lot of workmen interest. So the Diem can also say wait for some time because of some local festivals or some local elections. Most of the people, they also take some kind of arguments or pleadings that the industrial court or labor court has already given a stay on the properties of the company because of the dispute with the workmen under the industrial dispute under the Indian Industrial Dispute Act or under the Payment of Wages Act, and that all will actually be detrimental to the interest of the lenders. So this image that I am showing, this will only show how we at times the SARFAESI act as a destroyer of the value. So this is the image of the factory in the website of the company, and then the picture on the left is the image of the same building while the company was working under stress. And once the borrower knows that this is the once the borrower knows that it is not possible for me to continue with the factory and the creditors will take it away, then what he is leaving for the creditors is the other two pictures that you can see. We have seen in India, there are a lot of contractors in the market. They take this kind, they provide this kind of service that in case you negotiate with them, they will give you some money and they can go into your building, so they can remove whatever is sellable in the market. So whatever is sellable in the market, they can remove except the civil part. That's what they agree with. The civil part would be left. So this is the civil part which is left in the building because the building was mortgaged. So this part was mortgaged to the banks, whereas the entire everything else, whatever is removable, sellable, that has been taken away by that contractor. So this is a sad scenario of SARFAESI. In many cases that we've seen, people do like this. So along with the practical experiences of Diem order, we also have listed other issues which the borrowers are taking to CMM, Diem, CJM, and also at times to DRT. Also at times to DRT, that the bank has given notice for the for SARFAESI action for taking physical possession of the asset. However, these are the facts of the case. So they try to take injunction, they try to take stay. They first is and most popular is the tenancy of the third party in the asset. So they would first say that the property is not in our possession, it is the tenancy, it is under tenancy property. Then the property is not separable from other properties which are not mortgaged to lenders. Somebody is having a factory and some part of the land is not mortgaged to the bank and some part of the land is mortgaged. The promoters, the borrower will say that it is not possible to hand over the possession because there is one gate, there is one entry, there is one this infrastructure, one superstructure. However, the two land title deeds were there. One is given and the other is not given. So one is the mortgage, the other is not mortgage. So this is indivisible. So there is no possibility of taking the possession of this property. This is also very, very common ground that the borrowers are using. Property is not identified by the banks, so they feel it's difficult. So the Patwari is supposed to identify the property. That's a time-consuming thing. They can even file a family partition suit or a kind of self-declaratory suit in the court, only with the objective of delaying the issue, or only with the objective of the bank not able to take any recovery action from that property. That the objective is that. They also can file some suit between the family members in a court by finding out some nexus to that purchase of the property with the ancestral funds. So they can always say that this property belongs to HUF, even if it is in the name of one individual. The family members normally challenge the authority of the borrower, authority of the person who is mortgaged the property to the bank, and they would always say that this property belongs to HUF, and they would create some dispute. So the HUF property is not, it was not supposed to be given to the bank and pledged to the bank. Some will say the conveyance deed is defective. It is the conveyance deed is duplicate. The service of the notice is challenged. The 60 days was not there. The claim of the lenders is not complete. The conflicting documents, limitation period, property details are not proper. NPA status classification is not correct. The objection and the representations were not attended to. It was not responded to. It was still open. The borrower has made some payment after the notice. This is also which is being used now very by the borrowers. They deposit some money and then finally they say that the amount mentioned in the order in the notice is incorrect. OTS proposal is under consideration. Some other procedure, the rules have not been followed by the lenders. This is all excuses that will be taken by the borrowers. Some of the legal understanding of the physical possession. The legal understanding is that the lender will not become the owner of the asset after taking physical possession. The lender will only become trustee. The lender will not become the owner. They will only become trustee. When the physical possession doesn't mean transfer of title, the possession is only for realization of security interest and not for use. The bank cannot say that after taking over this property, I can even open my office there. In case the bank has to do, the bank will have to follow a separate process. That now this property is purchased by me. So they cannot simply sit on the property and don't sell it, and without selling it, they complete using it. So this is not for use, this is for realization of security. Lender would act as a receiver till the asset is sold. It has been held by the court that reasonable force is permitted while taking possession. Even after possession, any benefit from the asset would go to borrower's account. This I already discussed, that after taking possession, in case there is any income coming on that asset, that will also go to borrower and it will not stay with the creditors. And if the creditor has to take this amount, they will only use it for the repayment of debt. There are various orders on the Diem. Now these things are being settled over the years. Now the role of the Diem is quite settled. The role of the Diem is merely to assist in taking possession. Either merits or rival contentions of parties are not within the scope of the powers. The role of Diem is purely executionary. No adjudication required has been held in some cases. Diem to verify two aspects to be only. Whether secured property is identifiable, whether the secured assets fall within his territorial jurisdiction, whether the notice under section 13(2) of the NPA Act is given or not. No adjudication of any kind is contemplated at this stage. Then Diem is not empowered to decide the question of legality and propriety of any of the actions taken by the secured creditors under section 13(4) of the Act. No adjudication in the nature of land or on the question as to whether any due was payable or whether payments were made or not. Diem cannot entertain disputes relating to the jurisdiction of secured assets. This K.R. Chandrasekharan and others versus Union of India, this was the Madras double bench judgment. This judgment has provided guidelines like how the Diem order, how the Diem should attend to these issues. Then this particular matter, it is the direction which has been given. Finally, that has actually become a part of the affidavit. Finally, that has become part of the affidavit. So we actually can see this is a part of the affidavit which is provided now. See, the other question is the tenant and the landlord. So anything till now, because see, we have shared a lot of practical experiences of DM order, and maybe that some people can ask, or some questions are there, Ankit, Manjuji?
In fact, there are many questions on this. Ankit, you would want to speak about Sanjay Gupta has posted, no? The last thing.
Yeah, so there is a question which says that basically we trying to talk about how the tenancy rights can be handled practically. That is a question, because there is this method of blocking the borrower from blocking the secured lender to exercise rights under SARFAESI is pretty popular. So what can distinguish the lease kind of a system that is used to block SARFAESI operation? This is a practical question. What can be seen in the rent agreement?
Let me first of all explain this question. This is a judgment which is seen as a vital judgment in this part. Harshad Govardhan Sondagar versus the International Asset Reconstruction Company, and again Vishal and Kalsaria versus Bank of India. So it has been held wide and again that this section 13 of the SARFAESI Act is not overriding the section 68 and 69 of Transfer of Property Act, which provides the rights of the lessee and the lessor under a valid lease which is created prior to the receipt of notice. So they are not talking about the prior to the release of financial assistance. So the concept of financial assistance, execution of documents, in most of the documents, the banks have actually stipulated that the possession of the property would not be passed on to any other person without the consent of the bank. But what courts are saying, that if the tenancy is created prior to the receipt of notice under section 13(2), that tenancy would be considered as valid, and the rights of the tenant would be considered as valid, and the SARFAESI is not, it is not possible for the DM to take possession from that tenant. Possession of the secured asset by a lessee in accordance prior to creation of mortgage and in accordance with section 65A of the Transfer of Property Act, not terminated as per section 111 of Transfer of Properties Act, then no order by the CMM DM to pass the possession of the secured asset to the secured creditor. When the lessee voluntarily surrenders the right to the secured creditor, then of course there is no question. Dispute regarding the valid tenancy to be determined by DM by adhering to the principles of natural justice accordingly pass orders. This is also important that to prove tenancy, produce proof of execution of the registered instrument. If registered oral agreement, then DM to come to a conclusion that tenant not entitled to possession from the date of instrument or the date of delivery of the possession. This is regarding some of the unregistered and oral agreements where the DM has taken a decision that would not be valid. However, the non-registration of the lease agreement does not render tenancy nugatory. If there is a lease agreement and there are evidences of rent being paid, rent being taken, there are evidences of genuine lease over there, those all are protected. Attention must be paid to the relationship between the two parties in the lease agreement and their rights and liabilities. In case it is given to a son or even related parties, that would not be considered as a lease. Fact that there is a regular payment and acceptance of the rent is important. No undue advantage can be taken on the basis that the lease deed is unregistered. So these are some of the judgments regarding the tenancy part. So if we conclude any genuine tenancy is valid. So SARFAESI has no right to take possession from a tenant. I think this answers, Ankit.
I think that does, and I think we are already at 1:30. So we need to, I think maybe you can finish the presentation that is left, and we can maybe answer the remaining questions later.
I think Manjuji, is there any important question? Because see, like this presentation, I can quickly finish later, and maybe that we are able to extend by another 15-20 minutes the session. If
in fact, the question was only this, that if there is a tenant, can the secured creditor take possession of the property? I think you've answered that question. If
yes.
I understood it right, is that the tenancy rights are to be protected if it can be proved that he is a genuine tenant. But after the mortgage has been created and the borrower gives the property out on rent post creation of mortgage, will that tenancy be also valid?
Sorry, but I just lost attention. How much? What did you say? Sorry.
One question was that the borrower has created mortgage in favor of the bank, and post creation of mortgage he rents out the property. Then this tenancy right will be over and above the bank's mortgage rights?
That's what I read. I said that the tenancy has to be genuine, and it is not the timing. The tenancy has to be genuine, even if it is after the mortgage is created. The tenancy is valid. This is what I said, and there are laws. However, the tenancy, yes. See, I lost your voice.
No, my question was, the tenant is there. If the tenant is staying and there are tenancy rights, then banks cannot take possession. I'm trying to
banks cannot take possession. The tenant is there, and even if the bank
symbolic possession, and they can still do the sale, no? While tenants'
symbolic
rights can be
possession,
protected of the tenant.
The symbol. See, when we take symbolic possession and then we sell, see, like what banks have started doing now is that in case there is a tenancy, and in case there is a duration of tenancy, maybe the tenancy is for 1 year or 1 or 2 years, so the banks start selling the property, and after the sale, it is stipulated to the buyer that we will hand over the property to you only after the lease period is over. Then the application is made to Diem for taking physical possession, and then even after the sale, the physical possession is taken.
Okay.
So anything that the banks can do at the stage of creating the mortgage which will prevent this tenancy problem?
So at the time of creating the mortgage, of course, the bank normally go and inspect the property, and they would see that it is in the possession of the borrower. It is not in the possession of somebody else. That's the basic objective of inspection by the bank officials. So then after the inspection is done, after the mortgage deed is done, then even after the loan is taken, after that, in case somebody gives it on rent to someone and the lease deed is valid, it's a genuine transaction, it is not something within the family, then it is protected even after the mortgage, because see, like what is considered here, in case we take an example of a residential flat or a house, any person must have taken some loan, and after taking the loan, that person is still staying in the house which is provided to him by the government or by the employer, and he rents out that property. So everyone, after taking a loan against the property, after mortgaging the property, everyone is even giving it on rent. If you see, most of the executives in this country, they buy first house, second house, third house, fourth house, because they pay out of their salary installments, and they also earn interest rent out of that. So in case any such tenancy is not valid, where the property is mortgaged, then most of the tenants will first ask the mortgage situation of the property. That is not practically seen in the market. I haven't seen any tenant checking your mortgage rights, because the tenant say that I would register my rights of possession, and that is valid. And I say that even after mortgage is created, any tenancy which is right, which is genuine, that is valid, and the SARFAESI cannot be invoked on tenant. Correct? Okay, Ankit?
Perfectly good.
Okay, so I now go to a very, very common question, whether the symbolic possession and physical possession. This dispute has also seen a lot many litigations, whether the symbolic possession is required, physical possession is required, or even only symbolic required or only physical required before banks can sell the property. See, of late it has been settled now, because see, in 2018 the rules were amended. In the rules, it is very specifically provided whether the property has been taken on constructive or physical possession. So the sale certificate, everything has been amended to that extent that the constructive has become part of the documents now. So it is very clear that from 17th October 2018, it is now clarified that the property can be sold even after taking symbolic possession, and physical possession is not required. However, it is very difficult to get customers unless you take physical possession. And in case we start selling the property on the constructive possession, then even the physical inspection of the properties are not really possible, because somebody is already occupying and normally borrower, so they would not let anyone have inspection for the purpose of purchase, only for the sake of delaying the matter. Physical possession under section 14(2) may be taken after issue of sale certificate based on symbolic possession. This was held in Chennai High Court in Cortical tea plantation judgment on 30th of July 2009, that the physical possession is not required, so it can be taken even after that. At times, this Punjab and Haryana High Court even decided in a case that the lender should only take symbolic possession, and in between, but then finally that was turned down by Supreme Court in the case of Transcore versus Union of India. This was also a very, very popular case, Transcore versus Union of India. It was turned down. So in another case, like in a writ petition of Cortical Co-Operative Urban Bank Limited versus Balakrishnan in 2008, it was held that in terms of section 13(6), there is no legal or jurisdictional error in the sale being held by the secured creditor on the strength of the de jure possession. That means symbolic possession or constructive possession. It also held that where the secured creditor has completed transfer on the basis of de jure possession, is entitled to apply to assistance of Diem to take de facto possession of the security interest. So we have seen, like in some cases, the banks are not taking physical possession and they are only resorting to the sale on the basis of constructive possession, on the basis of symbolic possession. And in some of the reasons that we have listed out of our experience, the first, which is not even listed here, which I have just thought, the banks normally don't take the physical possession because it might even involve a lot of expenditure on preservation and protection of the asset, and that expenditure bank may not feel as worth the value of the property. Then in some cases the property identification is not correct, the police force is not cooperating because it requires break open of the locks, and the police says that for break opening of the locks they need a different process. Sometimes police force is little less as compared to the resistance from the borrower's family, friends, and the workmen. The borrowers also take a lot of stays from various courts. Some stays are from DRT, then possible from some high court, then it's possible from some stays possible from the workmen, like industrial dispute court, labor court, or any even the rent control court. So these are the kind of stays that normally we've seen that the people are taking. Workers are resisting. In the case of larger factories, workers have never allowed us to take possessions. Borrowers pending dispute with the workmen and attachment order given by the local court or a labor court or industrial court. Borrower normally rush to the bank at the time of taking possession and ask and request for some OTS, also pay some money immediately to the banks, and the banks direct us not to take physical possession. Wherever we faced large units where the operations are continuing with huge workforce and large areas, it's difficult to take physical possession, actually difficult. Then some local leaders our local police at times is not interested in providing help to us in taking physical possession because of the large factory, or because of some other issues like local festivals, like local elections. So this was the part on the physical possession. This was the part on the physical possession. So we've shared with you all our practical experiences. So there is another subject which was asked by some of the participants yesterday: the purchase of the property by the secured creditor under SARFAESI. The law is under section 13(5)(a) that the sale of the immovable property, if it fails for want of bid at a reserve price, the first condition is that there should be a sale, and there should be a failed auction. Second condition is that the secured creditor can bid for immovable property at any subsequent sale. The purchase price of the property shall be adjusted with the amount of claim of secured creditor. But however, the provision of section 9 of the Banking Regulation Act has to be seen, because the Banking Regulation Act provides that in case secured creditor wants to take over the property and they want to become the owner, then the section 9 of the Banking Regulation Act is applicable, and that section 9 says that there are some conditions in case the banks are supposed to take over the properties, and one condition is that such property shall be held for at least 7 years. So this is the major condition, so that this is a major condition for even banks buying their own property mortgaged to them. Now we come down to this sale of secured assets by secured creditors. There is a separate sale process under the rules, and the sale process under the rules, that is for the movable assets, it is there in Rule 6 of SARFAESI rules. It provides for, it's a very long process. It provides for the giving sale notice in the newspaper, sale notice to the borrower, and there are complete structure provided here. What should be disclosed in the notice, what should be disclosed to public, how much time is required to be given to the borrower for making payment. So all this is provided under section 8. Rule 6 is for movable assets, and Rule 8 is for immovable secured assets. So the process of sale of assets is like completely tardy. All that we can even tell somebody who is actually post specific question on anything. Otherwise, the distribution of the proceeds of the sale of assets is provided under section 13(7). First, it says that it will go to the all costs, charges, expenses. Then it goes to the secured creditor who are having first charge. Of course, as per the priority, in case the money is left, they can still go to the second charge holder before it goes to the borrower. So before it goes to the borrower, the first charge, second charge holders, they would first take their dip from the sale proceeds. After that, if there is still any money left, then it will go to the owner of the property, or any person who has rights or interest in that property. In case of liquidation of a company, in case there is still any asset which is under SARFAESI being invoked by the banks, the amount shall be distributed under section 529A of the Companies Act 1956. I think there is a corresponding section under the Companies Act 2013 also, maybe 292. I'll check. The secured creditors who opt for relinquishment of his security interest to liquidator can realize his security interest, because see, this is also possible, as it is possible under the insolvency law, that in the case of winding up, the official liquidator may not get relinquishment from the secured creditors. In that case, the secured creditor will sell the asset and will deposit workman dues. After depositing workman dues, then the sale proceeds would be distributed. Sale cannot be made if the amount of dues is standard. Section 13(8) is specifically providing one situation, that in case this any money is tendered before the publication of notice, or even practically even after that, if before the sale is confirmed, then the sale cannot be made. However, it is written in the law that before the date of publication of notice for public auction, or for inviting, or before even inviting the quotations or tender from public, or before even private treaty of for transfer by way of lease, assignment, of sale. So these were three situations. Before this, if any money is tendered by the borrower or any party interested in borrower's money, then it has to be like the property has to be given back to the borrower. Any action that we take under section 13.4 or 13.9 for between 13.4 to 13.9 for the sale of the assets or for taking any action, 66% of the secured creditors' consent is required. I'll just take one minute break.
So in the meantime, I will like to address the attendees that we will continue today's session on Wednesday. We will once again share the link for the registration to Wednesday's session on all your emails. The correspondence that we had shared today with everyone does include the link to Wednesday's session. It is scheduled for 4 p.m. on Wednesday. That session will continue today's discussion. It will take us to a brief about IBC and then take us to a comparative analysis of SARFAESI and IBC. This is the information I wanted to share. I was just sharing that we are scheduling the next the next session for the extension of today's session on Wednesday, and I was sharing the registration details with everyone.
Yes, yes.
I'm also putting this on the chat box.
Okay.
So you can continue with your presentation.
There are two questions.
Yes, yes.
No, I thought I'll ask these two.
Yes, yes, you can ask these questions. Because your voice is breaking a little bit. Maybe because of some internet connection.
There is already a interruption. One was you've talked about as is, where is, and as is, what is. So people are asking what this.
The concept of
very few. There is a huge. Yeah.
The concept
there is
of
a huge.
Abhisi, your voice is actually breaking. No, you see, I'm not able to hear your.
Maybe I can repeat Manjari's question. The question perhaps is the concept of as is, where is basis, and that basis is what needs to be understood, because what it does is then it shifts a lot of responsibility on the prospective buyer to purchase the property with respect to the title of the property, with respect to the condition of the property. So, some deliberation on that.
Now, see, like my understanding about as is, where is basis property, that means that the due diligence of the property, the legal due diligence of the property would be done by the bidder or the buyer.
When between my connectivity goes away. I hope you are able to hear me. That is the reason I switched off my video also.
Now it is, yes.
One is as is, where is, and as is, what is. What does it mean? Second is will the interesting question.
Still, I'm not able to get clearly. I could only get as is, where is, and as is, what is. I can explain that, and maybe that we
What
wait
does
for
it
the
mean?
correction. So as is, where is, and as is, what is. That means that, like, as far as this legal documentation and the physical inspection and the physical due diligence or the legal due diligence is the responsibility and the obligation of the buyer, and it is no representations are being given by the seller. So
Yeah.
all this has to be done by the buyer. As far as the legal diligence is concerned, the legal diligence has to be done by the buyer by just looking into the document which the bank has in possession. So as far as the as is, what is concerned, is that that has to be it is the based on the physical and technical due diligence of the product, of the asset, which has to be done by the buyer. So the banks are not taking any responsibility. Banks can only assist you, guide you, provide you all the information for the due diligences. So as is, where is the regarding title, location, and as is, what is the regarding the condition, usability, and so there is no representation. So that there are no reps and guarantees by the seller. So whenever there is no reps and guarantees by the seller, so that means that the buyer has to buy at its own risk. So the primarily it is the no reps and warranties in the product. So since this is not a commercial transaction, the bank is not in the business of selling that asset. So there is no reps and warranties. Later on, any buyer would not be able to go back to the bank that the machine is not working, or the building is dilapidated, or the building is just demolished, or it completely within 1 year. So there is no reps and warranties attached to these transactions, wherever it is written as is, where is, and as is, what is. So that means the as is, what is means that the condition, and you actually have to just do the due diligence yourself. As is, was, as is, what is, like that you have to just see the ownership of the or the entitlement of the bank, everything that you have to see and do the diligence yourself. So this is what exactly this means. So before moving to something which is
So this answers
like
the
which is
second question.
interesting, now I am able to hear you. Can you just repeat the second question?
Yeah,
Again, I
I
lost your
think
voice.
your answer to the first
No,
question
no, no, not able
answers
to.
the second question also. Second question was that the buyer gets a non-defective title. Ankit, can you hear me? If you can hear me, or I talk to you on phone and then you can probably ask.
The one thing is that the turn off webcoms, because that is what is the indication which has come to me, slow network connection and turn off webcoms. That's what is the but then Ankit also can turn off the webcom, and Manjuji also already done. She's already done that. So this is the what is the
Manjuji, you can simply ask the question to me on chat. I will repeat it.
so I can even go ahead with my next slide. It is the
So the
concept
question
of like, as I said.
So the question was that can the buyer get a defect-free title to the property that he or she purchases from the bank under SARFAESI? There, I believe my suggestion and my thought process is that they may not get a title which is better than the bank's title. So in case the property is subject to some kind of a fraud, some kind of a problem in the title deeds, then that defect will pass on to the purchaser.
Certainly, because see, like, this is the buyers to be aware of what they are buying. So the condition in the sale notice, as is, where is, and as is, what is, that condition stipulates that the legal meaning of this is that the buyer be aware as regards both parts, like title and the condition of the property. So this is answered. So as far as the manners and the effect of the takeover of the management is concerned, as I also said yesterday, today also I would say this is one concept. which is never been implemented in this country. It is similar to what IBC says, that in SARFAESI also there is a provision that the banks can take over the management of the business of the borrower, and the bank can also manage it. Bank can also add their own directors. Bank can also appoint an administrator for business management. See, however, the bank has not been able to do that, maybe because I understand the reasons could be that the banks, as insolvency and bankruptcy is concerned, there is a complete infrastructure which has been created for this part of the SARFAESI Act. There was no infrastructure which was being created. The bank was not able to understand how it is to be done, who will become directors in the company, who will run the company, who will become the administrator, and in case there is a continuous losses, who would actually fund the losses. So these are the various things that the banks might have even thought. See, this is the similar provision. Section 9 is also there in the asset reconstruction companies part of the SARFAESI Act, where in that case the RBI has come out in guidelines, and then later on consolidated those guidelines in Master Circular in 2012. However, no such guidelines were given for the implementation of this subsection B to section 13.4. So what we are saying, that in the management and takeover of the management of the borrower is not something that we can do. It is not practically possible because of the lack of infrastructure. Quickly adding to, because there is an application that somebody can file, any aggrieved person can file application to DRT under section 17. The time limit is 45 days. And this application originally, as far as the SARFAESI Act is concerned, it is supposed to be disposed of in 60 days. And in case the DRT is not able to dispose it of, maximum in 4 months, but this is not practically being happening because of the over occupation of the courts and the tribunals. And this is same is happening in NCLT, same is happening in the same was happening in DRT. So the appellate authority in this case is Debt Recovery Appellate Tribunal. But then the biggest thing in this appellate tribunal is that in case of any appeal which is being filed, which is to be filed to DRAT, then 50% of the total debt has to be deposited before any appeal is entertained by DRAT. The DRAT has power to reduce that amount to 25%. However, the Supreme Court has held that it is not possible, even on an order from any other high court, that the DRAT can reduce the amount of deposit even at the direction of any other court, any other high court. So this is an exclusive power with the DRAT. So I have another Supreme Court judgment with me which says that it is nobody can give directions to DRAT for reducing this deposit. So this is an appeal issue, and as I said that this SARFAESI Act 2002 was amended in this January 2020. That was the part of the SARFAESI. Now the SARFAESI transaction, the banks are supposed to register. Banks are supposed to register the transactions of mortgage before SARFAESI, and after 24th of January 2020, the banks would not be able to invoke SARFAESI action in case this transaction is not registered. In case this transaction is not registered with SARFAESI. So in case then this is the condition which is effective 24th of January 2020. The second good part is that in case the transaction is registered with SARFAESI, then even after the sale, even after this, the bank will have, the secured creditor will have priority over any other claim, including the claim of central government, state government, local authorities against any taxes, against any revenue. All that would not be there in the claims. So this is the section 26E specifically says that once it is registered a transaction, then the bank will have priority over everything. So this is somehow matching with the IBC now, so that the priority of the bank would be there. So there are some landmark judgments. I would already say that we've already exceeded our time, so we would not take up these Supreme Court judgments, and we would try to, anyone would request us, we'll try to do that. And I only would say thanks. And before I say thanks, I think Manjuji can talk to the participants for a few minutes.
Maybe the network will not allow her. She has had some problems. So in Delhi, we are having a lot of strong winds, which perhaps have caused some network issues at her end. Anyways, I think we have a lot of questions. Some of them are with respect to SARFAESI. And one question that has come in is whether unsecured loan transactions can be registered under SARFAESI by the lender. Secondly, if the government department has registered their, so they cannot be registered, that's answered. Secondly, if the government department has registered their dues lien with SARFAESI, how the claim of financial creditor would be impacted, disturbed. Two conditions: if the government transaction is registered before FC's registration date with SARFAESI, or it is after that.
No, the government's transaction registration is not important. What is important is the attachment of any asset by the government. Attachment of any asset by the government, and the transaction of attachment is registered. The transaction of attachment is registered, then of course the government would have lien on the proceeds. So in case there is an attachment on the asset, but then simply just by registering the government's due is not important. The attachment transaction has to be registered on a particular asset. Then of course the secured creditors will, because these are difficulties like the secured creditors have been facing under SARFAESI Act also, because whenever we go for taking physical possession, we actually find the attachment orders on the property by various, like even PF department, income tax department, even other ED, like under PMLA, under any other act. So all those attachments, we are not able to, under SARFAESI, we are not able to take possession of those properties, where under IBC we are able to take. So my answer is in this case that attachment of asset is important, not the outstanding dues under any act.
Well, the concerns that has come in is that since Wednesday is a working day, many bankers may not be able to attend it. So a few of them are requesting for a session on a holiday. I believe next Saturday is also a working day for bankers.
Yes.
So
yes.
maybe we can schedule another session for the part 2 of this program on 3rd.
On Sunday morning.
Sunday morning, the same day today. After a week, it can be done like that.
Yeah. No. Yeah. See, after a week means like after Wednesday, we can have this repeat session on Sunday.
Yes. So we will also share details of that with all the participants.
Right. So if of course I know there'll be a lot of questions. Even yesterday we had 100 questions. We will try to somehow see how can we attend to those questions.
So we will, I think, compile the answers to the questions that have come in, find out the unique questions, and then maybe circulate it amongst the attendees. And otherwise, the questions are way too long. They will consume a lot of time. It is already 2 o'clock.
Right. So thank you very much, participants. Thanks a lot for being with me for more than 2 hours. And it is my pleasure, and it is my way of learning, and nobody else than me has earned knowledge out of it, because your questions, yesterday you have given me 100 questions, and today also you may have given some questions. I will look into those questions, and I would say thanks you all for spending time with me, for giving you the questions, so that I update myself and I equip myself to handle those questions. That's my way of learning. Thank you very much. Goodbye.
Thank you. Thank you, everyone.
Thank you.
I should close it for everyone now. And